Well, hello, everyone. I am excited to be here today. My name is Sharon Toerek, and I am the founder of Toerek Law, which is an American law firm with people in multiple states. My home base happens to be Cleveland, Ohio. And what we do is we help marketing agencies, independent marketing agencies across the country, protect their assets and turn their intellectual capital into revenue. And so Christian and I have been talking for a few months actually about how to best add value to Quick Mail's agency distributors, resellers, the folks in the Quick Mail network who do business as agencies, about how to consider thinking about legal to grow your profits as an agency and reduce your risk. And I think the starting point for today's conversation is really to get you in the mindset of thinking about legal affairs as a profit center for your agency. I know that legal can seem like a cost or an investment or a necessary evil in the day-to-day of operating a marketing agency, but really, I think we're going to provide some examples today during our discussion about how you can think of your legal affairs really as a revenue driver. And even as a risk reducer, it's about preserving profit and preserving revenue. So we're going to talk about three main ways to do that. One will be your agency agreements. One will be thinking about your agency intellectual property differently in terms of creating new revenue streams to run alongside your fee for service work. And then we'll talk briefly about a trend we're seeing for agencies to run more profitably and actually take on work that might not be normally within their sweet spot, and that is the agency to agency strategic alliance. And I know we had some questions submitted in advance, and if we've got questions today amongst attendees, we'll take questions and have a little bit of a conversation there. So our presentation today is the three keys, and let's talk about the first key, which are the contracts, specifically the necessary contracts. In my view, after running an agency-focused law firm for a number of years, that every agency should have. We'll also give you a couple bonus ideas about some additional agreements you may need to have, depending on your specialty. But these first five are, in our view, the contracts every agency needs to have to preserve profit and reduce risk. The first one is a contract that's very important to agencies in the business development phase of their work, and that is the mutual disclosure agreement. Most of you are familiar with an NDA, but briefly, what is it? It's really the agreement that defines how the parties are going to behave with each other in terms of preserving confidentiality and keeping information and ideas secret and undisclosed to third parties. A lot of agencies are very reluctant to broach this with potential clients out of a fear that it might make them look a little bit complicated to do business with, or that it might not set the right tone for the conversation. And I'm going to encourage you to get past that a little bit because think about the number of times you've sat across the table from a prospective client and they have pushed their non-disclosure agreement across the table at you and expected you to maintain confidentiality of the client's relationship. So this is just approaching the issue in a spirit of mutuality, and it's focused on the agency also protecting its ideation and its ingenuity and its strategies from being taken by the prospective client who ends up not doing business with you and either executes them internally or worse with a competing agency. So we consider the mutual NDA the gold standard here when it comes to protecting your assets and preserving them and maintaining the value of them by setting the table at the beginning of the conversation regarding non-disclosure. What are some of the key highlights that should be in an agreement like this? And we'll go through these very quickly for each of the top 5 agreements. But, and I think this first one is sort of a key to helping a potential client feel comfortable signing this agreement. Stress that it's mutual. You are going to maintain confidentiality of the client's information, and in turn, you expect them to retain confidentiality and respect your ownership of the ideas and strategies you're bringing to the table during that conversation. You want to contain a definition of confidential information. That seems a little silly to call out, a little obvious perhaps to call out, but you want to use that definition section of a mutual NDA to include your agency's ideas, strategies, and disclosures during the new business conversation. If you define that, include that in the definition of confidential information, the agreement covers it more automatically. And again, an ownership statement regarding the agency's intellectual property is also important. So those are key components, and it's a little bit about why a mutual NDA is a must-have for every agency. Contract 2, and this is sort of the apex of agency agreements. In my view, this is the agency master service agreement, and you may call it a professional services agreement. You might call it a letter agreement. You might include legal terms instead in a statement of use or a proposal, but this is the contract that defines your relationship with the client. It's a linchpin of your policies, your procedures around money, around IP ownership, around fair competition rules between the parties, and also to define the deliverables and compensation that the agency is going to receive for its services. So why do you need it? And I included this question on this slide for a specific reason. We have a number of agency clients who say to us, we do business with large enterprises, or we do business with charity organizations or with government agencies, and they make us sign their contract. And that's our primary client base. Why do we need a contract of our own? The answer is that you'd be surprised how many times in those cases, those clients will actually default to your contract form, first of all, and you won't know that until you show up at the table with one. Secondly, having your own master service agreement or equivalent gets you to the negotiation table faster and gets you through the negotiations more quickly, because it acts as a set of benchmarks or almost like a mental checklist amongst your agency account team about what are the things that we need to include in every agency commitment that we enter into with the client. Having your own contract is the best way of setting your benchmarks and your expectations. And it sets the table differently in terms of your negotiation when you show up having considered in advance all these points relative to your business relationship. What is our policy with respect to non-solicitation of our employees? What is our policy with respect to exclusivity? What is our policy regarding late payment? All those things. If you show up having considered those things for yourself and expressed your own viewpoint on them, it sets the table differently for the conversation and gives you more basis for pushback, even if you are going to end up using the client's paper. So it's a critical document for every one of you to have in your toolkit. Here's a list of some of the key provisions that a master service agreement should address. It's not exhaustive, but you want to make certain that you've got a clear statement of work that goes along with the master service agreement. I call this the document that includes your 3 Ds, your deliverables, your deadlines for doing the work, and the dollars. So a description of the work, the timetable, the money, those all go in your statement of work, which should be an integral part of your master service agreement. IP transfer language. Most of the time, if you're doing customized fee-for-service work for your clients as an agency, everybody intends that at the end of the day, the client is going to own that work. However, as an agency, you want to make sure you're transferring it at the appropriate time. So no money, no IP transfer to the client. A very important leverage point for you as an agency, and therefore a very important point to include in every master service agreement. Your indemnification and your liability limitations. We could do a whole clinic on negotiating master service agreements, so we don't have time to go deeply into all of these, but you want to address liability. What are the limits of that liability for you as an agency? Publicity rights. You want and need the ability to share examples of work you've done in the past for clients when you do business development in the future. You probably would like the ability to display the logo or names of clients you've served in the past to sort of provide some social proof of your capabilities. That should be negotiated in your master service agreement, because there's too many times when clients will put a prohibition on that in their version of your contract, or they'll require you to ask them every single time. And that's a little less than practical after the relationship might have concluded. Exclusivity restrictions. Again, this could be a very long conversation, but I'll keep it brief by saying this is increasingly a hot button issue for agencies in client contracts. Clients are getting bolder and setting expectations higher in terms of exclusivity of the agencies they work with, meaning that you cannot work with a competitor or someone in the same product category or service category. So this has to be well defined. And if you're going to agree to exclusivity of any type, you want to make sure your compensation reflects that. So very critical to address in your contract. Talent non-solicitation. We are still, even though the climate's changing a little bit right now as we sit here in late 2022, talent is still hard to find and retain in agencies. And you certainly don't want your clients who have access to your best people recruiting them for work and out from under you as an agency. So non-solicitation is important to address. And then your payment and collection terms. Most agencies are pretty good about articulating those, but I would just say on that point, if you want the ability to recover your lawyer's fees or your collection costs, if you're not paid, you need to put it in the agreement. So that was a fast tour through the MSA. Again, we could talk about that in a session dedicated just to it, and I'm happy to take questions about it at the end. All right. There isn't an agency that we work with at our firm that doesn't engage with freelance talent or contractors on occasion, either to expand your bandwidth temporarily or to perhaps bring a skill set in-house temporarily that you don't currently have. And so the independent contractor agreement is a critical piece of your legal toolkit. And it is the document that defines your relationship with this third-party contractor, talent, freelancer, anyone who's not a W-2 employee of your agency who's going to contribute work to you. Why do you need it? Obviously, for IRS compliance here in the United States, it is one factor amongst many in terms of distinguishing an employee from an independent contractor. And by the way, just as an aside, please don't refer to your contractors as contract employees. They're not. It's one or the other. They're your contractors or they're your employees. The IP ownership of the work that these folks do for you it's critical to address that in this agreement. It is possible to pay a contractor for work and not own the intellectual property rights to it. That's an unfair concept seemingly, but it is the way the copyright law works. And it's also something you need to address for waterfall purposes, because you don't want to promise a client of the agency that you're going to give them rights to work that you didn't obtain from the freelancer. So very important to address IP ownership of the work that the contractor creates. And then obviously fair competition rules like confidentiality and non-solicitation. And in this case, you want to make sure it includes not only talent, but clients. You don't want contractors working directly with your clients without your permission. So some key provisions, we talked about a few of these. You want the intellectual property to vest in the agency when the work is created. We've talked about non-solicitation, very important. Publicity rules, publicity rights rules, just like you want the ability to publicize specific work or specific client relationships, perhaps. You want to make sure you're in the position to control the way your contractor talks about those relationships on their private portfolio sites. You don't want them representing your clients as their clients. You don't want them displaying work on their portfolio sites without you knowing about it or giving permission. And then you want warranties in this agreement that the work they've presented to you is original, that they haven't infringed on anybody else's work rights, and that they're complying with all the marketing laws they know about. We have had a few cases over the years at my firm, unfortunately, of freelancers who were discovered to have plagiarized after the fact. Agencies in these cases knew nothing about it, and we definitely had to do some walk back. So you want to make certain you're keeping tabs on that and reflecting it in your agreement. All right, contract 4. The agency strategic alliance agreement, I'm only going to touch on briefly because we're going to talk about strategic alliances later on in the session, but it is the agreement that defines the agency to agency collaboration, what the rules are amongst agencies. I want to say that a lot of agencies default to using their standard client agreement or master service agreement to reflect agency to agency relationships. It's not the right document. First of all, the relationships are very different that you have with your strategic alliance or your strategic partner agencies. You're more positioned as peers with the end client. And therefore a client services agreement is really not the place to reflect this relationship. So you need a separate agreement, and we'll talk a little bit more about the rise in strategic alliances and white label relationships a little bit later. And then I also find that this is an important agreement to have in your toolkit, because otherwise agencies tend to default a little bit too frequently to informality. Let's partner up to pitch this client, or can you write this part of the proposal, or can we light label this part of the work for you, without adequate agreement in place between the parties about what that really means and what the rights and responsibilities are. So it's a very important agreement to have at your disposal. Key provisions. Is this going to be a white label relationship? In other words, not disclosed to the client? Are you going to present their work as your own to the client? Or is it going to be disclosed, and are you going to be positioned as peers? That's something to address. Who's going to be what I call the owning agency of the client relationship? Who will handle the client communications? Who's going to bill the client? Who's going to manage the client's account? Who's going to project manage all of the work that you're doing for the client? That has to be defined. Clear swim lanes. Which agency is going to do what work? Liability and indemnification, and insurance. In this case, you want to make sure both agencies have it, and you want clear guardrails between the parties about responsibility for their contributions to the end client product. And then obviously fee and payment policies and provisions. Are you the main agency not going to be responsible for paying the strategic alliance partner until you've been paid by the client? Are you expected to front the money to the strategic alliance agency? Whatever your arrangement, you've got to set that in writing in the agreement. All right, the fifth and last, what I call essential agency agreement. This is just my arbitrary title for this document. You may call it something else. You may call some of the provisions that are in this document, you may put them in other places, but we call it the Employee Business Protection Agreement. It might be an employment agreement. It might be an employee policy and procedure handbook. The bottom line is you need something in writing that defines your rules and expectations and the employee's responsibilities on issues like IP ownership and fair competition as an employee of the agency. Why do you need it? Agencies who want their employees to behave fairly in terms of competition, going to work for a competing agency, moonlighting, taking on side gigs. You're at a loss if you don't actually have a policy in writing or an agreement in writing on these points. And so our way of addressing this is a business protection agreement. I'm fine if you address these in other legal documents. They just need to be talked about and agreed by both parties in writing. And the employees need a fair chance to understand what your expectations are on these points. And you can't assume that they understand what those are if you haven't reviewed them with them in some place where they can actually see it in black and white. Some key provisions to include in a business protection agreement or its legal equivalent are their work for hire status, meaning that all the work that they do as an employee belongs to you as the agency. That is the way the copyright law works and the way employment law works, but you just want them to understand that this is not something for you to go splashing on social media without our permission or on your personal portfolio site without our permission. Non-solicitation. If you leave us, don't go after our clients. Don't recruit your fellow employees here to go with you. Non-competes, I mention them really with hesitation because they are disfavored in just about every state now in the US. They're also very highly misunderstood. So, and they are not the same as non-solicitation covenants. So know the difference. Know that a non-competition agreement for an employee is going to be relatively impossible to enforce in most states. And where it is enforceable, it has to be written very narrowly and be determined reasonable by that state's standards. Confidentiality, that's pretty straightforward. And moonlighting, and as I said earlier, work portfolio display policies and procedures. All right, so bonus round really quickly. We just gave you the 5 essential contracts to reduce risk, preserve profit. Some of you have specialty agencies, and so I just want to mention briefly some of these other documents that might be important for you. First of all, if you're the type of shop that not only has long-term or bigger dollar relationships with clients, but also does smaller projects, then you may not need a whole MSA for every single client engagement. It may be overkill in some of your projects. Have a set of short form terms and conditions that you can include in your proposal or statement of work that is an abbreviated version of your legal terms that you can incorporate and have one document signed. If you do a lot of direct response marketing, or if you do a lot of social media advertising or audience building, data privacy is an extremely important issue for you. If you're an email marketing firm, data privacy is extremely important. So a data privacy addendum that defines the responsibilities of the parties for protection of data is very important as well. If you do website building and website maintenance and hosting, then these next 2 are for you. A maintenance and hosting management agreement is an important document to have. It's a long-term, typically perhaps month-to-month arrangement, and it's a little bit different than your main original build assignment was. So having that separate agreement in place is important, and having a model set of website terms and conditions and privacy policy. And also, I didn't put it on the list, but ADA compliance language. Those may be important for you to have in your toolkit as well. Publicity release documents, if you're doing a lot of content creation and you need agreements for things like on-camera interviews or being on property and taking photographs, things like that, publicity release is an important document to have in your toolkit. And I've called it talent agreement, but also if you're an influencer agency, an influencer agreement, if you do a lot of influence marketing, that's an important document to consider. So those are the contract essentials we want you to consider as a risk reduction and profit preservation tactic for your agency. But what about those of you who want to actually create a new stream of revenue using the intellectual property that you've delivered? This is a topic I'm super passionate about. Again, this is one of those things that you could do an entire session devoted just to it, but we're going to give you a bit of a taste of what our framework is that you can use to help evaluate the IP that you may have at your agency to make a decision about whether monetizing it separately is an option for you. So we use a framework that I like to call our triangle framework for evaluating the intellectual property that you've developed. At one point in the triangle is your content. And I'll give you examples of what kind of content we might mean in a minute. This is the actual stuff you create, right? The manifestation of all your knowledge. So we'll give it examples in a second, but it could be a course, it could be a video, it could be a podcast. It's what you've created that has value and the actual tangible expression. The legal framework for protecting content is almost always copyright. Sometimes it can be trade secret, but for the purposes of today's conversation, we're going to focus on copyright. Then there's your brand at the second point of the triangle. And this is the way you identify what it is that you put out into the world, how you name it, how you identify it, how you brand it. And then transactions. This is the way that you actually make money with your IP when you productize it. And it can be licensing, it can be sales, it can be a lot of things. I'll give you a couple of specific examples in a moment. And typically the way you protect this kind of IP is in some sort of contract or agreement relative to the customer or client's ability to use the IP that you've provided to them. So let's talk about some examples of content. Digital course workbooks. A lot of agencies develop an area of genius and decide to create a do-it-yourself course based on that. So the actual workbooks, the videos, the photography that it gets incorporated into the deck, podcasts, software or mobile apps. A lot of agencies create electronic solutions to problems that they see over and over again. Some agencies develop training programs, something in between a do-it-yourself and a we do it for you, sort of a done with you training program, and they create very sophisticated training materials. This is the type of content we're talking about when we talk about content on the content point of the triangle. Brand, these are your word trademarks, your logos, your product names, your taglines to brand not only the agency, but you may name a specific product or offering or framework that you use at your agency to do something. And this is protectable IP as well. And so those are some examples of some of the brand focused IP assets that you might create. And then transactions. I want you to think about transactions into the agency and transactions out of the agency. We talked about independent contractor agreements, and the reason I mention it here is because if you're going to productize a solution, create an online course, create a training session, create a virtual event of some kind, typically you've got freelancers helping you create that stuff and put it together. So you want to make sure you own all the IP in it. Another reason why the independent contractor agreement is important. But let's talk about transactions out. Remember that when you do a work for hire for a client as an agency and you intend the client to own the rights to it at the end of the day, that's a transfer of rights. But anything less than that, if you're going to retain the rights, create something once and sell it multiple times to multiple people, that's a license. And so anything short of an outright assignment of what you've created is a license. And there's many different ways to create licensing agreements and arrangements, but that's a transaction that protects your IP in consideration for you receiving money for it. End user terms and conditions, we're used to seeing these in software and mobile apps. It's no different in the products that you might create as an agency. And distribution agreements, you might create a product or a service that you have other agencies or parties distribute or sell to third parties on your behalf. And that's a distribution agreement with a licensing component. So brand, content, transactions, those are the 3 points of the triangle. Trademark, copyright, and agreements are the legal mechanisms for protecting them. I wanted to provide you with a few actual real world examples that we've actually seen at the agency of our clients who have actually done these things and put work out into the world that wasn't customized for just one client. We've seen our agencies do paid training sessions where they create a learning module and deliver it multiple times for a set fee. Do-it-yourself courses, virtual events. One of our clients in the tourism industry obviously hit very hard during the pandemic, brought together a bunch of subject matter experts and thought leaders in the tourism industry because their clients obviously were freaking out too during the pandemic, and created a virtual event where they could help their clients figure out what marketing strategies might work for them during a pandemic or what other things they could do to make money. Memberships and subscriptions, where you might put out information or content over a regulated period of time for a seat-based subscription. We've had clients conduct their own original research and package it into white papers or database access subscriptions and earn money doing that along with the marketing work that they do in that segment. Content libraries. We've seen clients who focus in a specific industry or niche create rich content that they can license to multiple clients to use for newsletter articles, for blog posts on their website. And the agency retained ownership of it and simply licensed the right to these non-competing clients to use that content. Private podcasts. This usually goes along really well with a membership or a subscription, but where you're creating really rich, really valuable content in audio format and charge a fee to have access to that. And then everybody's favorite and first example, usually when you talk about IP for agencies, some sort of technology like a mobile app or a software as a service application. where should you start? If this is something that you want to explore for your own agency, taking your IP and creating a new revenue stream, take a look at the client work that you've done in the past, particularly if you are a niche agency and you represent a particular vertical on a regular basis. Look at the client work you've done. What are the opportunities you've helped clients take advantage of? What are the problems that you've helped clients solve? And look for the patterns that you notice. That's usually a good place to start in terms of turning a framework into a productized solution or some sort of turnkey offering that you can create for other people to use. Look at the solutions you've created for those problems. Did the solution that you created for one or two of your clients, is that something that could be universally applied to other similarly situated clients? Sort your IP into categories. We just went through the triangle framework. Use that sort of as your guideline for sorting assets into categories to figure out what you've got and whether or not IP protection is necessary or important for you. And then a question I get a lot is, how do we know if it's worth investing in intellectual property protection for this stuff if we don't even know we're going to be able to sell it? So I would say, look at the market worthiness. You're the marketers. I'm not the marketer. Look at the market worthiness in your target client base for whatever it is you might want to offer or package. And where it seems like the dollars and cents justify putting an offer out there, that's where you make investments in legal due diligence to protect the IP, whether it's trademark registrations, copyright applications, agreements drawn up for licensing of that stuff. All right, that's a lot. The third, we've already touched on a little bit, so I'm just going to briefly refresh your memory on agency strategic alliances as a profit center for you. This is an opportunity for all of you who don't have a capability in-house, but do have an opportunity to sell that service to one of your clients, or those of you who might be thinking about adding a particular type of offering or service, but you need to test the waters first. Agency to agency strategic alliances are important for this reason, because they reduce your risk, because you're only taking on the headcount or the responsibility, if you will, for a limited period of time. It gives you a chance to test it out. It gives you a chance to experiment with margins and pricing so that you can understand whether this is going to be a profit center for you or a necessary pass-through, even if it isn't profitable, because you want to keep the client happy and you're selling them other profitable products and services. So for this reason, and I've thrown up again the slide here with some of the key provisions, we saw this earlier, but I want you to know that we are seeing a dramatic increase in agency to agency strategic alliances, strategic partnerships, white label relationships. And I think for multiple reasons. First of all, it's a tough talent market out there, and this is a way to get access to talent that you might not be able to hire for yourself, or at least hire affordably. It's a way to take advantage of an opportunity with a client that you might have to let pass you by if you don't have the capability in-house. And it is potentially the beginning of a collaboration between you and your partner agency to go to market with a unique combination of solutions or offerings that nobody else can provide or compete easily with. So we're seeing a market increase. 2 of the last 5 interviews I've done for our agency focused podcast at the law firm have been about white label relationships. And so it's definitely a trend you need to understand in terms of its ability to increase your agency's fortunes. So that is the third key. I am super appreciative for you hanging in there and listening to some of our thoughts on these issues. And I'm going to take a breath, and Christian, I will throw it over you for whatever questions that we've got either in the chat, or I think we had some submissions ahead of time today.
Yes, thanks a lot, Sharon. This is really eye-opening to see how you need to have this part of your agency covered, so you don't either suffer from it by, I don't know, not including something crucial in your contract, or not knowing that you can monetize something that you've been doing and not knowing about it. So it's a lot of stuff. Very interesting to me. I hope to everyone. We'll jump into the questions that were submitted. So TJ, you obviously get priority in the queue. So I'll start with your question. Sharon, TJ is asking if the NDA and MSA contracts be combined, so that and DJ says that so that you're not bombarding the clients with all of these documents.
Right. I totally appreciate the desire to not want to make a client feel blizzarded with paper. So I have a two-part answer for you on this, TJ. Yes, you should put a non-disclosure clause in your MSA. And that doesn't necessarily mean that you don't need a separate mutual non-disclosure agreement, because your conversations with the prospect may be lengthy, and you may very well be exposing some of your best ideas, suggestions, and strategies to a prospective client before they actually sign your MSA. So in many cases, you will need both. You'll have to use your business judgment about how abbreviated the conversations are before they actually sign your MSA. Or if you're not giving, if you're the type of agency that has very standardized solutions for opportunities or problem solving for your clients, and you're not giving a lot of IP away in advance, then perhaps you don't need the mutual NDA. But most agencies we work with have sort of that brief, uncomfortable period before they know whether or not they've sold the business, where they've given away some either hopefully you're not doing speculative work, but there are still agencies doing that out there. So giving concepts away, giving campaign ideas away, giving strategy ideas away in the actual courting phase of the relationship before they're actually agency and client. So I think you need both in your toolkit. If you're not disclosing a lot of IP in your pre-contract conversations, you may be able to rely just upon the confidentiality language that's in your MSA.
Does that answer your question, TJ?
Okay.
Yes, it does.
But while you're at it, you had a different question. Do you want to ask a kind of live about insurance, I think? You're muted. You're muted, TJ. I just asked you to unmute. So go ahead. Yeah.
Hi, let's try this again. So I'm going to pivot away from my original question I asked in the forum. So basically how I have all my contracts sorted out is that I have the MSA, and then I have project work orders. So the MSA is like the general thing. And I think I do have an NDA in there. But then I also have for every single project that the client wants to do, because I do branding and web design, I basically have a project work order. So instead of them having to sign the MSA every single time, I just have them sign the project work order. So that way it's for that project and everybody knows the rules and engagement of that project. Is that a good way to go about it? Or should I have the clients always sign an MSA for every single project order?
No, you're doing exactly the right thing. You don't want to overkill your clients with having to sign a multiple page contract every time you do a new project for them. So that's absolutely right. Just make sure you're incorporating the terms of the MSA by reference into the SOW or work order every time they sign it.
Okay, awesome. Thank you.
Yeah, you're welcome.
Nice.
I like cozy, intimate webinars like these.
Yes, it's definitely an opportunity to get some to free one-on-one consultation time here. So
Yeah,
I'm happy to do it, because I think anybody listening to the replay afterward will have similar questions too.
right. And also, sorry, I was just on the top of my head as well. So I'm in Canada. Are the rules or kind of similar with Canada versus the US, or should I look specifically into my jurisdiction for, like, let's say Alberta or Canada copyright laws? Are they, like, in your experience, are they kind of in the same ballpark?
In my experience, they're very similar, but I am a US attorney, and so I can't even give you generalized insight into any specific things you might
That's
need to
fair.
consider. But our trademark and our copyright laws work very similarly. So I think the contract principles and the IP protection framework that we proposed here works in the US or in Canada, but you do need to make sure there aren't any local or regional or national specifics that need to be covered in your agreements, because I can't speak to those.
Fair. Awesome.
Yeah.
I'm sure I'll have like bubbling questions at 3 o'clock in the morning.
Well, my contact information is definitely here. And so things that come up afterwards, feel free to reach out.
Awesome.
And then Christian, I think we had some questions submitted in advance that I think would be great to answer, just so that whoever's getting the replay has access to that information as well.
Right. So we have two that are along the same line, and you also kind of partly answered them. So Mark is about client contracts. So Mark is asking, what's the best way to protect ourselves from non-paying clients? And then Rawad is asking, how can I stop a client from replicating the same strategies and solutions I gave them once they've stopped working with me?
Okay. So I think the answer to the first question is being very clear and specific about the penalties for non-payment in your MSA or your contract. That works as an excellent deterrent. I think a client faced with the prospect of having to be responsible for collection or legal fees is going to take its obligations to pay you more seriously. I also think this is just, and this is more business maybe than legal, but I think the way you build milestones into your work, if you're the kind of agency that can work on progress payments, that can help you front load your payment before you deliver work, so that you're not as exposed for unpaid fees. And I think that's another thing to consider, the way you craft the payment timing and obligations, as well as, and certainly don't be, in my opinion, advancing costs for production, media purchases. Make sure you're getting that money up front. If you want to bill your service revenue, in arrears after you've completed the work, that's a business decision for you to make. But I think building milestones in and separating out, third-party expenses versus fee revenue is also important to do, as well as billing penalties in, so that there's some teeth behind. And this is the other reason also, by the way, why you don't transfer intellectual property until you've been paid for everything in the contract, because until they paid you, they don't own the rights to use the work, which gives you additional leverage, which most agencies are reluctant to use, and they shouldn't be, because it's your number one asset. You're right after your people. Your IP is your most significant asset, and you should not be giving it away until you've been paid. So that's the sort of the payment question. And then the second question was protecting yourself in what I would call the new business situation, from having a prospect take your ideas or strategies or suggestions and executing them without you. And the mutual NDA during the business development conversation is the very best way to handle that situation. But if you haven't done that, or if you're reluctant to ask for one, to the extent you're sharing your ideas, your strategies, your concepts in writing, you can use those written tools like the proposals, the estimates. You can include copyright and intellectual property ownership language in those documents, so that it's very clear that they are your property and not to be shared with any third party without your permission. So those are some things you can do outside the realm of the NDA to at least put a little bit of teeth into your claim that that's your stuff and it should not be used without your involvement.
Thanks, Sharon. It's very helpful. We'll take two more questions. One is kind of a beginner, starting out question. Jay, who's also attending, is asking, how early in your agency is it recommended that you register it as an official business?
Well, before you take in your first dollar or sign your first agreement, ideally. You want that veil of separation between you personally as the owner of the business and the rest of the world, whether it's a client, whether it's an independent contractor. Certainly, if you're going to be an employer of people, you want to have an entity. So my suggestion is immediately, once you've decided you're hanging your shingle and putting yourself out there, as an agency or as a business, you should have an entity formed. You know, because short of that, you're really just running the business as a proprietorship and exposing yourself individually to liability, for either mistakes or breaches or any of those other kinds of things that can go sideways, in a business.
Yep. Leila is asking, how do I qualify the best lawyer to help me draft these types of contracts?
Mhm. Well, I think lawyer selection is, it's a combination of individual chemistry between you as a business owner and the lawyer who you choose to work with. You've got, I think, to have sort of that know, like, trust relationship with them. And, you know, beyond that, I think that you need a lawyer who's well experienced in business to business matters, because you're a business dealing with other businesses, usually as an agency. And then third, you know, in my experience, there aren't very many lawyers out there who focus on the agency world. So I would say having someone who understands your industry, your business model, the way you make money. You know, at a minimum, I would look for lawyers who work with other service businesses, so they sort of understand the predicaments you can get in, and they understand the value of your intellectual property, because that, as I said earlier, that is your number one asset, number one stock in trade. And in my view, you need to work with a lawyer who not only understands the business aspects of your enterprise, but also the fact that you make money by creating and either selling or licensing intellectual property. And they should be able to protect you in those types of transactions.
Got it. Nice. All right. So, how can people find out more about you and what you do, Sharon?
Yeah, thank you, Christian. So my contact information is here on the closing thank you slide. I know that a quick mail, excuse me, who I want to thank for having me today, by the way. Christian has been wonderful to work with, and quick mail, I think, is very, very generous in putting out this kind of content to help their distribution partners really be stronger businesses, because that's better for everybody overall. And so thank you to Christian and to quick mail for having me. And they are going to be sending out some follow-up materials to all of you, and those materials will provide you some additional information, but also have our contact information on there as